and welcome back to Family Law and More. We're your hosts. I'm Isabel Hawkins.
And I'm Lisa Edmonds.
And today we're very pleased to be joined by Dr. Kate Hellin. Dr. Kate Hellin is a consultant chartered clinical psychologist. And in her 30 years at the NHS, she worked with people with personality disorders, substance dependence, and in psychotherapy and general community mental health services. Since 2007, she's been undertaking psychological assessments of parents for the family court, and she has a particular interest in the conflictual dynamics which can occur around families, between the agencies with whom they're involved, in the controversial matter of parental alienation, and in assessing parents of children with perplexing presentations, and also in cultural sensitivity in psychological assessment. Her psychological assessment of the parents involved in Lancashire County Council against M and others was described in Mr. Justice Hayden's 2021 judgment as a landmark report, the analysis of which requires wider dissemination. So welcome, Kate.
Thank you.
So, Kate, just to help our listeners understand how you and I connected, you got in touch after listening to our second episode on family law and more, which was about Part 25 applications in the family courts. And you said to me, Lisa, I've really enjoyed listening to it, but I was jumping up and down at times. So we've given you the opportunity to join us today so we can tease that out a little bit and find out what was causing you to become so animated. And maybe just to remind our listeners what episode 2 was all about, it was in relation to when an application is made to a family judge for an expert assessment. And usually we're having discussions around this topic through the lens of public law proceedings. So that's when a local authority is involved. And we are now, and have been for some time, but it's definitely at the forefront of everyone's mind about the mandatory 26-week timetable that we've got to achieve resolution within. And so as a result of that, in our second episode, we explored the impact that is having on advocates that turn up in a courtroom, make an application for an expert assessment, and judges maybe more often than not in the current climate saying, no, that assessment is not necessary. And Kate, you will know that we've had recent judicial guidance that reminds all those engaged with the family justice system that social workers and guardians are to be considered experts in their own field and maybe not losing sight of the fact as to what they can bring to the table. So with that reminder in place, shall we start off with why you were jumping up and down, Kate?
Well, I was jumping up and down, particularly at the point at which you were talking about the way in which psychological assessments seem to be very often a method of the trouble being the inevitable consequence that they cause delay, because what happens is that psychologists identify trauma, and then the trauma is identified as needing therapy, and that therapy is almost invariably either not available at all, or it's just not available within the time proceedings of the court. And so what happens there is that you get a psychological assessment, which in itself incurs delay, and that all that comes out of it is a recommendation to something that will be either unachievable or it'll cause further delay. And I did jump up and down at that point, not because I disagreed with you one bit, because it's a bugbear of mine and something that really bothers me greatly, but because I think it feeds into the issue of several misunderstandings in some ways. So one bit is about what the nature of trauma is. So most of the parents that I see, especially in public law proceedings, have had history of adverse events, many of them through their lives, and those could be described as traumas. But what that doesn't necessarily mean is that they have been traumatized or that those events have affected their parenting. That doesn't necessarily follow. So people's reactions to life events will be very individual. Often parents say, well, I've got over it. It didn't bother me that much. And then unfortunately, that's sometimes feeds into the idea that they're in denial and that's a further problem to be addressed. Whereas in fact, the impact of trauma is something to be assessed, and one can't assume that it has been negative. So that's one part of it. But the second part of it is that therapy is but one option for parents. And I worry hugely. The bit I really jumped up and down was when you explained that you almost never, if ever, read a psychological assessment report that doesn't recommend therapy. And it's a funny world that we work in as expert witnesses, where we very often don't see many of our colleagues' reports because we're jointly instructed experts. And I thought, is that right? Because if that's right, there's something very wrong with psychological assessment reports, in my view, because therapy is but one option. I think it's a version of psychological arrogance, actually, to assume that therapy is the only option for people who have suffered distress in their lives. I think psychologists, as all expert witnesses are instructed to assist the court. That's to find helpful ways of informing the court to make the best decisions. And I think we know then that if we make that kind of narrow recommendation, we're likely to be consigning a family to an almost invariable outcome of non-reunification because therapy can't be found. There are so many psychologists who work in other ways. In the NHS, therapy is but one form of intervention, and many psychologists are working with in assertive outreach teams, for example, where they're engaging with people in a far wider form of ways than therapy, usually about helping people to establish their social infrastructures in a more robust way that helps them to stabilise. It's often about working with the system, often the family system, sometimes with other agencies.
I'll give an example. This was some work I did a number of years ago when I assessed mother in care proceedings. I'll call her Sarah. It was her sixth, I think, set of proceedings. She'd had children removed repeatedly from her care and placed for long-term foster care or adoption. And the issues were broadly the same each time. She committed a serious criminal offence, but something like 20 years earlier, and nothing since then. But nonetheless, there was a resting level of anxiety about her because of that potential. Made much worse, I think, by the fact that she was very assertive, feisty, and verbally aggressive. She had an enormous degree of suspicion towards authority figures, and she did not want to work with people in the way that they wanted her to work. There were constant relationship breakdowns with professionals, and ultimately that resulted in children being removed and not returned to her care. She'd had lots of assessments in the past, psychiatric and psychological. And there was a question about whether she had a personality disorder or not, and there were varying views about that. I had really interesting instructions in that I was asked to assess her, but also to overview the previous assessments. And it was very clear, really, that there was this pattern of relationship breakdown with professionals and very high levels of anxiety about her and about what she was like to work with. I think she was downright intimidating, really. I didn't think she had a personality disorder, but in fact, that wasn't really the crux of it, because whether she did or she didn't, she was very clear that she wasn't prepared to have therapy. That wasn't even on the cards. And what happened at my recommendation was that instead of trying to intervene with her, the intervention was aimed towards the various professionals, the various staff who were working with her. And at this point, it was probation officer. She was on a life licence, the independent reviewing officer, the social worker. They were the core members of this group, facilitated by a very experienced clinical psychologist, very used to supporting staff working with difficult clients. And much of it was about helping people to, first of all, understand why Sarah was behaving so aggressively, that it came from anxiety and desperation. And as people understood a bit better the psychological formulation, they were able to see, I think, more clearly the fact that she was really in most ways a very good mother, very attuned, very sensitive, very loving, with great potential. The group helped staff to think about the times that Sarah became challenging, and rather than exert controls over her, insist that she reported more frequently or that she, attended more appointments or whatever it was, demands which she then resisted vigorously, creating more antagonism and a negative feedback loop, that instead of that, staff would think and sometimes do nothing or do less and support her in a different kind of way through listening and understanding rather than making demands on her.
That's a very general way of putting it, of course, and there was a lot of detail lying behind it. But ultimately, it was about reacting as little as possible and containing rather than controlling. And it really worked. Sarah was able to become calmer, a bit more trusting, a bit more able to engage and do what was needed. And staff were less anxious about her. And I'm very pleased that in the end, her baby was placed with her. She's had another child, and the local authority didn't actually issue proceedings in the case of the second child. And I know the children are still with her. I also know it's not perfect and there are rocky moments, but actually I think the system around her has been able to contain her. And that's a great example, actually, of a time that a systemic intervention really worked.
Do you think there's a place for bringing back or bringing into greater focus the advantages of what we would usually call experts meetings, professionals meetings, that multidisciplinary conversation? Because just taking your point about being surprised that the reports that I've seen in practice would often recommend just therapy rather than something more bespoke to the actual needs of the family. If we're instructing a psychologist, say, out of area, and they're not familiar with the wider resources that are available, and of course, as an expert to the court, your conversations with social workers or other professionals working on the ground might be restricted because of the practice direction that you've got to operate within. Have you ever sort of engaged in that multidisciplinary meeting before you've completed your report so you can, as the expert, undertake that matching process and make recommendations that can be realised? Because I think that's my frustration that I was trying to get across in episode 2, that the recommendations may be valid, but they're sort of theoretical because we just can't access what's being recommended. Whereas maybe if it was turned the other way round, before the report is finalised, that due diligence has been undertaken to make sure that it's a valid recommendation, and therefore the whole delay for obtaining that assessment has really become purposeful because we can very quickly go on to implement the recommendation. I don't know what your thoughts are on that.
It's an interesting way of thinking about it. In the olden days, if I can put it like that, there were many professionals meetings, and I attended those very regularly with probably most cases, most families that I was involved with, but always after I had completed the report. And I think the reasoning there, which I'd go along with really, was that my independence might be compromised if the professionals meeting came a bit earlier on. I do think that out of professionals meetings, there was then scope for something of a synthesis really of approaches and a contextualization of recommendations within a locale, within local knowledge of local resources, and that could be helpful. So that would be perhaps one way of addressing things. But I think the problems probably arise much earlier on, which is it's partly about the notion that a psychological expert has in mind at the point at which they approach the assessment at all. And I think that's to do with the instructions, the wording of the instructions, and we might want to come on to that. But I think the way that I've always approached it is that I've done my best, and it hasn't been too difficult. I think partly because until relatively recently, and of course, as the years go by, this becomes less the case, but I did work in the NHS in the Northwest, across the north of England, and had, I think, fairly good grassroots knowledge, experience, understanding, sense of, if you like, local resources.
Yeah.
But not only that, I'd know people. So if I did have an instruction in an area that I didn't know as well, I would ring up, I would find out. But nonetheless, I understood the infrastructure, if you like, of resources, because they are, in the main, reasonably common. You know, there's primary care psychological therapies, there's secondary care psychological therapies, there are tertiary services, and those vary more between areas. But it's not impossible to find out quite a lot about those services. So the due diligence, I think, was done as part of the assessment, and I would be involving that thinking in my recommendations. And I would also be careful in the form of wording so that my reports would be quite often setting out therapeutic options, but being very clear that that was probably a desirable but possibly not achievable. And if not achievable, certainly not within the timescales, then this, and this. So that there was an array of possibilities, realistic ones. This isn't a fishing trip. This is about what might really make a difference. And sadly, there are sometimes cases where I've ended up saying, unfortunately, I have no recommendations. That too can happen. But it's about thinking outside the box and more flexibly. At whatever point that's brought into a wider domain, a wider professional conversation, that too will be useful.
Yeah. So I think, again, I don't know what Isabel's experience has been recently, but to secure, good experts who have a reputation as being good, you have to wait a long time. And just tying that up with what I said in the intro about the 26 weeks now being in sharper focus, do you think for justice to be done and to get good resolution for children, actually we do need to compromise on timescales because quality is more important than delay?
This is one of these rocks and hard places. It's really complicated. I worry hugely about the compromising quality because it is possible to receive a report which is just either takes the court no further forward whatsoever or is unhelpful and may actually result in courses of action that lead to potential injustices. And I'm speaking very abstractly and theoretically, but I do think that's entirely probable. There are lots of ideas put forward about how to try and fill the gap that a delaying expert psychological assessment might otherwise create. And I think each of those have problems as well. And we can talk about these. I think it's possible to anticipate early, and I know that this sometimes happens, is that someone will get in touch with me very early on and ask if I can hold a timescale in the possibility that an instruction might be considered by the court later. And I'm always happy to do that. If I don't get that instruction at the end of the day, that's really not the end of the world. It does allow some sort of planning. But I don't think there's a simple solution, but I would be very wary of the court compromising too greatly on quality. I think I've seen, and I'm sure you have as well, a situation in which the timescales have been adhered to, but really at the 11th hour, there's a coherent argument made that there's an evidential gap, that there are serious questions that a psychological assessment should help to address. And an assessment is ordered very late in the day, which actually could have been ordered earlier and run in parallel with the case management. So there's no simple solution.
No.
I'm wondering, Kate, given that we do struggle for availability of experts, particularly as Lisa's made reference to, experts that are known and that are respected and that the quality of their work is, it's known. So do you have any comment on the recruitment and the retention of experts within the family justice system and what can be done to ensure that we have that expertise ready there to assist the family court?
There's a nationwide shortage of experts in most, if not all, of the different medical and psychological and psychiatric domains. It's a real problem. There's been a great deal of attention to this, both national and local, and attempts to create interest, to create training opportunities that help to address some of the concerns, fears, if you like, for practitioners entering the court arena, because people are worried about it. They're often alarmed about it, especially perhaps the more junior members of different professions. It's seen as being a very challenging place to practice. And I think it is in very many ways, but that doesn't make it beyond the competence of lots of people. So many pupillages, lots of other interesting opportunities, training events to try and encourage people. I think it remains really difficult to recruit and retain people. And there are a number of different reasons for that. But one bottom line, undoubtedly, and very sadly, is the rate of pay. The legal aid rate of pay is low. And the perception very often is that therapy is just so much easier to do without the scary prospect of ruthless cross-examination and so on. So it's difficult. I think market forces are not helping. A lot of us who do family court work, usually at legally aided rates, do it because I absolutely love the work. I find it really challenging, really intellectually challenging, but it feels very meaningful and really important. And I do it because it's very satisfying. But I am at a particular point in my career. And I think for many people who are coming forward, who are younger and starting out, it's a daunting and not well paid, not well rewarded prospect. So the solutions remain a bit thin on the ground at the moment.
Kate, can I ask, from an expert's perspective, do you feel that there's anything we can do as lawyers to, I suppose, firstly, achieve the best outcomes for children, but also maybe with an eye on that answer you've just provided to Isabel about us all playing our part in terms of recruitment and retention of good practitioners that are involved in the child protection system? Anything that lawyers can do to assist the experts in that sense?
I think this podcast is a great start because we're having the discussion. So that's really good. And I hope that might, in some ways, allay some anxieties. I'd like to think it would in people who are potential expert witnesses. There are opportunities for a great deal of support and backup. So there are lots of psychological agencies who work as interfaces, if you like, between the courts and the practitioner themselves, and very often will provide different spectrums of support, but often it feeds instructions, but also will help new people to think about how to go about the assessment if they're starting out fresh, and to possibly proofread or to have what we would call clinical supervision or consultation, which is not about interfering with someone's opinion forming, but it is about helping them to understand the framework of the work and supporting their confidence really in undertaking the work, preparing for court and so on. So there are those agencies who perform, I think, a really useful function. There are many pupilages. I think one of the ways in which I think the courts, not necessarily specifically the solicitors, but the courts more generally, could help both in terms of recruitment and retention, but actually more generally in terms of, I think, supporting psychologists to feel enabled to think more freely about the task before them in conducting a psychological assessment, would be in terms of the letter of instruction, because these are very much written in using a diagnostic or medical framework. So, to be very crude about it, the nature of the letters are almost always, in my case, because I assess adults, not children, it's what's wrong with these parents? Have they got a diagnostic category that we can define them by? Can we understand them in terms of a disorder? How does that affect their parenting? And what can we do about it? That's broadly, crudely the framework. And I think what that does is take a psychologist straight into the idea of there's something wrong with the parent, and a diagnostic type psychological assessment, which actually isn't psychological expertise. Psychological expertise is in formulating. And the formulation is different from the diagnosis because it isn't about providing a descriptive category, a label that would essentially describe the difficulties that someone might present with. It goes, I think, much further than that in trying to offer an understanding of why the parent is in the predicament that they're in. So it's not what's wrong with them, it's what's happened to them and why are they often recreating the difficulties that have led to the court's involvement. And we call that a formulation. And I think if psychologists were asked for a formulation, and the questions were also in terms of the wider system, the social support, that the psychologists would, I think, then feel more able to respond actually in line with professional identity and skills to produce a formulation with questions also not framed in terms of therapy. Now, I think that in my experience has probably widened out. So letters of instruction often are talking more about interventions, but I think the wording probably could go even further than that to be clear that what the court will need is things that can be realisable, that might make small differences, perhaps sufficient to restabilise a family, so that for the future therapy might be an option. But I think very often the framework is in terms of 26 weeks, diagnosis, intervention, and the psychologist feels constrained, whether consciously or unconsciously, by that. So there's subtle shifts, I think, in the letters of instruction that could make quite a difference.
I think that's a really good suggestion, Kate, because I often find that when you get a psychological report, if the recommendation is this parent needs 6 months of therapy or something like that, all the professionals just latch onto that. And that is the goal, then that's the aim. And if you're not at that point, it does often feel like this parent's got no chance. So I think that's a really good suggestion to move away from that rigid structure that we have.
And it really is the case. If one thinks about it, there are vast numbers of people that never get anywhere near the family courts, who have dreadful lives, who survive awful circumstances, past, present, who adequately and more than adequately parent their children. And that's because the infrastructure of their lives, their innate resilience, internal and external factors are sufficient. Psychologists know a lot about this. So do other professionals. So I don't want to claim this as sole psychological expertise, but I think sometimes psychologists are particularly able to look at capacity to utilize, capacity to change in those sorts of terms. None of that's to do with therapy. It's about looking at all those other elements. And if we can actually construct frameworks in which people can be better supported, we can make the difference. That means that children can potentially be safely returned to their families.
Yeah, I mean, I think it's definitely something that needs a further conversation, because in my experience, you very much see standardized questions. I mean, the letter of instruction is, of course, personalized in terms of setting out the factual background relevant to that case. But then the questions do tend to be more often than not generic. So, for example, I know you can go on the Resolution website and they have model letters of instruction. And I suppose if you've got a paralegal or someone that's preparing the Part 25 application and maybe doesn't know where to start, that would be the start point for them. But I can't remember the last time when I was at court where we actually engage with the practice direction and the letter of instruction is sort of dissected, for want of a better word, and has judicial either input or approval. So, yeah, I think that definitely is a small contribution maybe that we as advocates can play in making or creating the opportunity for more realistic outcomes for families.
Yes, and I think psychologists, I'd like to believe that psychologists can have more confidence in sometimes, if I can put it like this, subverting the instructions and saying that perhaps what the court might be better assisted by is this approach. So one can follow the instructions, and I do, because actually there's a great deal of merit in them. There's a clarity, there's a framework. It's not all bad by any means, but I think psychologists also have these various other ways of looking at things, but not necessarily the confidence to then bring that into the court. Yeah.
And how often do you receive then questions on the back of your assessments? Is that a tool that is used as it should be, not as often as it should be? What's been your experience?
Yes, I don't know how often. It's probably a minority of reports where I'll get follow-up questions, but it certainly happens regularly. I think it's usually a good thing. Dare I say, I think sometimes it seems fairly obvious that a solicitor is acting according to instructions from an aggrieved client. Yeah. And really, I'm asking questions which I've already answered pretty thoroughly in the report, but that's all right. I think that's fair enough. But I also think the questions often do, in fact, lead into something of a discussion which expands the thinking. And that's great. It also suggests to me that there's some sort of appetite for trying to utilize my recommendations or suggestions in a useful way. So on the whole, it's probably a good thing.
Yeah, because I was just, sorry.
With it is great.
Because I was just thinking, is that the tonic to that restriction that sometimes experts feel with the letter of instruction, when actually the questions come from maybe the trial advocates, or they're responsive to what the assessment has teased out, that allows the expert to have a conversation, obviously expressing opinion, rather than doing the formulaic assessment that maybe the expert feels compelled, has to, deliver that because that's the task that's been set by the court. So it may be that, again, we as practitioners need to reflect upon that and make sure that that isn't a step in the process that is overlooked.
Yes, I think that's a lovely way of thinking about it, really. It's anything that's able to generate a conversation, because a conversation is likely to be creative, expansive. It certainly has that potential. And whether that is through a professionals meeting, as used to take place at whatever point in the proceedings, or whether it's through further questions, there's the opportunity to get into some of the subtlety, the possibility, if you like, that lies behind the starker framework of typical instructions.
Well, Kate, thank you very much for reaching out and joining us on this podcast. And it's been really helpful and engaging to listen to your perspectives on what are topical issues for all of us at the moment working within the family justice system. I think you've been tipped off that we tend to close every episode where we're lucky enough to be joined with a guest with our game of Roll That Dice. So I'm hoping that you are up for it, so to speak. And if you give me a nod, we'll roll that dice.
That's fine. I'm terrified, but let's go for it.
Okay, here we go. So we have career highlight.
Oh, well, do you know, that's easy. And that was actually something that you read out earlier from my biopic, because I think my career highlight was the incredibly generous judgment that Mr. Justice Hellin gave and wrote publicly, which was about a case which I had been instructed on, in which there was the opportunity to think systemically and to offer a systemic understanding of a very stuck family in a very stuck system, a very fraught system in which there were multiple agencies and in which relationships had broken down repeatedly. And that was actually a great example of where I'd felt able to say that I thought the court would probably be better assisted, rather than seeing or asking for or identifying problems in the parents, which I didn't find, that there was a systemic process going on. And I was able to set out that in my report. And his very kind judgment, I mean, not only was that personally very rewarding for me, but it wasn't so much that as putting it out there in the public domain. And it's been an opportunity, probably one that's indirectly led to our conversation today on this podcast, that has, I think, opened up a lot of conversation with different people in different domains, and I hope might make a real difference in the family court. So for me, that's been really lovely, because it's potentially had an impact. And perhaps that's what everyone wants, to make the world a bit of a better place.
That's a great highlight, Kate. Thank you. Well, next time we will be back with Kate again. And that episode will be hosted by Chloe Booth and Bella Tate, who will be inviting Kate to share her expertise and experience on the topical subject of parental alienation in the family justice system. So it's not one to be missed. And please remember to subscribe, leave a review. And if you have any questions, then as always, please email us at podcast@unit.law. Thank you, everyone, and see you next time.
Thank you.
Thank you.